person live of 20.
I know. All right, are you Deshaun Robertson? And this is cause number 25 DCCR 0914. Ms. Robertson is charged with aggravated assault with a deadly weapon. Mr. Wilkerson has filed a motion asking that I reduce Ms. Robertson's bond, currently set at $300,000. And Mr. Wilkerson, you may proceed.
Yes, Your Honor, and in this case, just so the court's aware, there are several family members present who likewise could testify as to family support within the community, length of time in the community and community activities. What I would note, Your Honor, and what I would apprise the court is that even as of now, having received HIPAA releases from Ms. Robertson, we are in the process of receiving records from Spindletop and Fannin, Your Honor. We believe that condition can be fashioned, even if the court wanted to go so far in this case as home arrest. Your Honor, the truth is that because of some of Ms. Robertson's issues, she has had problems sustaining employment at times. I believe, if I'm not mistaken her, that she actually qualified for SSDI, but of course now that is stopped because she has been incarcerated, and she does have 2 children. One, I believe, is about to graduate.
I have one that's just graduated. He's going to the service, and I have 2 that are in school, in high school still.
And okay, so that was my misunderstanding then about the one that she was hoping to see graduate and obviously go off to the military academy. Your Honor, she does have, of course, the assistance of Miss Wynn, who is her mother, who is here, and also Miss Stewart, who is her aunt, is here, and then some of her children's here. Children are here, and even one of their significant others. Judge, this particular case, there are obviously some underlying issues. I think it just makes it a lot easier for us to be able to prepare this case and to undertake the evaluations and potential treatment necessary with regard to the matter. I can understand, of course, the court's reluctance to lower the bond given the severity of the incident, but I would hope that even perhaps Mr. Nichols might be able to throw some considerations out there that might include things like house arrest or GPS only that might give the court some additional comfort in terms of safety to the community.
So let me get some where would you live if you made bond, Ms. Robertson?
I have a house at 5555 Davis Drive with my kids.
5555 what?
Davis, THAMES Drive.
Who lives at that house?
Me and my kids.
Which kids specifically?
I have
That's okay.
the 18.
Okay. If it were a situation, Your Honor, where the court would prefer, of course, that she live with her mother, I believe that's a situation that could be worked out as well. She's willing to, I believe, take on that responsibility.
What about Spindletop? Is there a plan in place for you seeing it going to Spindletop before this incident?
Yes, ma'am. I need to get back on my meds, to get back on my medicines.
So had you stopped going like you were supposed to?
Yes, ma'am. I had medicine, to last, and then my caseworker ended up leaving, but I don't drive that far, because I'm scared to get on the highways and stuff, so I don't drive. I only know the north end of Beaumont.
So it's our understanding that there had been a lapse in treatment, Your Honor. I won't know more until, of course, I'm able to access those medical records, which I just secured releases for. So.
Mr. Nichols.
Judge, my concern is the severity of this case. She hit a man, ran him over in the car, left him pinned there when she got out and fled.
What is his status?
He was in ICU. This case has only been indicted for 2 weeks, so I do not know his current health condition. I think he's been released from the hospital. I know he was able to give a statement to the police, and I will be in contact with him to see really where we're headed.
Okay. For the record, I am reviewing the probable cause affidavit. There is only one incident at the jail, so that's not something that's of great concern. But well, actually it is of concern. Do you know why it's of concern? It's because it has to do with your medication.
It's blood pressure medicine that I was taken off of. I have a new prescription, and they keep trying to make me take it. I've been on that med since I was 19 years old.
So you thought the appropriate way to handle that was by writing F off on the medical stuff?
No, ma'am, it wasn't appropriate, and I did apologize, and I haven't had any incident with meds since then, and I did give them my med doctor information so they can get the correct medicine into the jailhouse instead of having me on the wrong medication, because I was told to stop that.
You get a whole lot more being nice than you do acting like that, don't you? All right, so what I'm going to do is grant the motion to reduce the bond. Going to reduce the bond to $100,000. A condition of that bond is that you are not allowed to drive any vehicle ever for any reason while this case is pending. Do you understand? Whatever that means as far as where you live, if you need to live with mom because you're not allowed to drive, then that's what you need to do. I'm not real worried about that. But I think if you're not driving, I also am going to order as a condition of that bond, if you make it, that you immediately make an appointment with Spindletop, that you follow through with any assessment, recommendations, medications. If you're not doing that, and I want proof of that, so you have to get proof. I want to know when your appointments are. I want to know what the outcome is. You have to get all of that information to Mr. Wilkerson so he can get it to me. If I find out that you've missed an appointment, that you're not taking medication or whatever it is, then that bond's going right back up and you're going to be in custody where I know everybody's safe. Does that make sense? Mr. Nichols?
No contact, staff premises.
Obviously, no contact whatsoever in any way with
Lyle Sanders.
You're not to go anywhere near 3215 Gulf Street at Tulane, wherever this happened. I don't know who lives by there or why you were there. Doesn't matter. You can't go around there. Do you understand? And this goes, don't send messages through anybody else. Nobody needs to be contacting him or his family or anything like that. Let all that go through your lawyers and they'll handle that. But don't send messages. It's not beneficial for her if y'all send messages or anything like that to him, okay? If you're caught doing that and I find out that anybody's tried to contact him on your behalf or you contact him in any way, bond goes up. Obviously, we have another big issue. Does that make sense? Anything else?
I think that should suffice, Your Honor.
All right, you can go back with the bailiff.
Thank you.
Thank you, Judge. I believe that's the last.
Thank you.
Be excused.
Yes, sir. Thank you, Mr. Wilkerson.
Thank you, Your Honor.
Let's see. I see one. All right, ma'am, you're Jamie Story, and this is cause number 23, DCCR 1546. Ms. Story was placed on probation February 25th of this year for the offense of theft of property with previous convictions, and that was enhanced to a third-degree felony. The sentence was a 10-year term in prison that was probated for 10 years. Motion to revoke was filed. We were here before, and Ms. Story pled true to all of the counts, 1 through 7. I've received the updated report. Have all of you had an opportunity to review that?
Yes, Your Honor. I have, Your Honor.
And are there any additions or corrections?
None from the defense.
Judge, my only thing that I would add, just for the court's recollection, and obviously I, of course, would not hold the court to this, we had some difficulty originally in getting her on probation. She volunteered a couple times. We kind of, based on her criminal history, made a stretch to make the offer. The court was inclined
Don't talk over
to
her.
go along with it based on some circumstances regarding her homelessness, etc. I do appreciate that she took responsibility for a motion. However, I have a note on my original plea papers that the state would be asking for primarily the max on a motion to revoke. But again, I know Ms. Holmes has an argument with some hard times that she's fallen on, and I'm not ignorant of that. I just want to let you know my position, what it was originally.
I appreciate that, Ms. Holmes.
Yes, Your Honor. I believe originally that was my concern with Ms. Story essentially having probation was her lack of resources, in which she continued when she was placed on probation in February of this year. That came to fruition. She originally was at her brother's home. That didn't work out, and then she went to go to Liberty with a friend, and there was pretty much lack of resources, lack of transportation, and she made the decision to then not contact because she got scared, and here we are. Your Honor, my main argument is that she has not been on probation long to get started. She never has gotten started. Now that she's been in custody, they visited with her at the jail to let her know what steps and what resources that they can provide, so she knows that she does have help. If she does fall on these hard times, that is what probation is for. We are asking if she could get that opportunity to get started so that she can get the resources and the help. She states that she's been in contact with her mother, and her mother would be where she would reside if she's reinstated back on probation to get things back on track. I do see in the recommendations that probation stated if she is granted reinstatement to complete the cognitive track of the intermediate sanctions facility, in which I've gone over that with Ms. Story, and she is willing to do that to have an opportunity to get back on track with probation. Your Honor, we do understand she does have extensive criminal history, and this is not her first rodeo. However, we are asking, due to the severity of how long she can be sentenced to prison, that she at least have one more opportunity to start probation and get back on track and get the resources that she needs.
I don't have anything additional, Judge. I defer to what the court deems appropriate.
I mean, what's appropriate is for you to go to prison for 10 years, probably, with your history and the fact that you got this chance in the first place, right? I mean, probation has all the resources to help you, but they can't go find you and force you to take advantage of those resources. That's up to you. You've been on probation, you've been revoked on every probation you've been on. So the fact that we gave you a probation now and that I'm even considering leaving you on it is making me question my sanity, honestly. Do you have anything to say?
I really am so sorry for disrespecting y'all.
I mean, when you never show up, it's pretty much like you're just flipping us off, you know,
I understand that.
for giving you an opportunity.
I understand
And it's
that,
hard
and
not
I
to
really
take it a little personal.
And I really am sorry, and I'm sorry for disrespecting y'all, and I will do it right this time.
What will you do different?
Everything.
Like what?
I'm gonna get me a job. I'm gonna go to work. I'm gonna go to probation. I'm gonna pay my fees. I'm gonna do everything that I'm asked to do.
Why didn't you do it before?
I didn't have a ride.
Well, but you could always call,
I don't understand.
right?
It's not my.
You know, if you don't have a ride again, what happens?
I'm gonna use the phone and call. I just had a granddaughter born, so.
All right, I'm going to do this. I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. But I'm not going to do that today. I'm going to continue you on probation. I'm going to order you to enter and successfully complete the cognitive track of the ISF program. You will be on 0 tolerance. If I'm telling you, I mean, if you are back in here, I really am going to see all of this. I see everything every time. And there's not going to be negotiations. There's not going to be, let's give you less than the 10. You've agreed to 10 years already. If you violate, it's 10 years in prison. And you can see your grandbaby when she's 5, 6, or 7 when you parole out. All right, so that's what's at stake, is a 10-year sentence. Not some lesser, maybe just 2 because you couldn't find a ride. You agree to it, it's all yours if you violate. Does that make sense? All right, go back with the bailiff. Good luck.
When the first defendant stepped forward, the entire courtroom shifted into a heavier silence. He carried the exhaustion of someone who had been fighting the system, fighting circumstances, and in many ways fighting himself. The judge looked at him with the kind of expression that wasn't angry but firm, like she had already seen this same story too many times. She reviewed his violations, his missed obligations, his choices that had slowly backed him into a corner. And when she asked why he didn't do the most basic things required of him, the excuses fell apart almost instantly. He tried to explain hardships, transportation issues, personal struggles, but the judge didn't let him forget one simple truth. Every resource he needed had been offered to him. Every tool was there. Every door was open. He simply didn't walk through. She didn't yell at him. She didn't need to. Her steady tone was enough to make the entire room feel the weight of his decisions. She reminded him that probation requires action, not just hope. And if he wanted a different outcome, he had to start showing effort rather than disappearing when things got difficult. Then she shifted, just slightly, from stern to deliberate. She told him exactly what had to change, exactly what she expected, and exactly what the consequences would be if he didn't follow through. She wasn't there to crush him. She was there to push him. And by the time he walked back to the bailiff, he finally understood that the judge wasn't handing out punishment. She was handing out his last opportunity. The second case carried a completely different energy. This defendant walked up with a mixture of frustration and fear. And the judge had already studied pages of jail incident reports, each one showing a pattern that couldn't be ignored. Fights, disrespect, disruption, every action painting a picture of someone reacting instead of thinking, escalating instead of controlling. When she confronted him with his own behavior, he tried to deny some incidents and minimize others, but the judge cut through all of it. She read out loud exactly what officers reported, word for word. She asked him directly why he thought he could act this way behind bars and expect a positive outcome in court. He didn't have answers, only fragments of explanations that no longer held weight. But then something shifted. The judge didn't just list his mistakes, she told him what they meant for his future. Every fight in jail translated to a lack of control outside. Every refusal to listen meant he wasn't ready for freedom. Every threat proved he wasn't understanding the real danger he was creating for himself. And then came the warning, clear, direct, and final. If he wanted any hope of changing his path, it had to start with his behavior right now. No more fighting, no more arguing, no more disrespect, no more excuses. His actions from this moment forward would determine everything. from bond decisions to sentencing to his entire future. Both defendants walked out with the same reality echoing behind them. The judge wasn't trying to punish them. She was trying to save them from themselves. The only question now is whether they will listen.